This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Roundtable. I'm your host, Noah Ballmer, and today I'm excited to welcome Paul Andersen to the show. Now, Mr. Andersen is a hazard analysis safety engineer for OSHA Compliance Services. With over 25 years of experience in regulatory compliance work, he is an experienced expert witness with dozens of engagements in a wide range of work safety matters, both for plaintiff and defendant side. Mr. Andersen, thank you so much for joining me here today.
Well, Noah, thank you. And please call me Paul. Mr. Andersen happens to be my dad.
You've got it, Paul. Let's jump into it. You've been in safety and compliance for decades. How did you first get started in your profession?
Well, considering that I've had 25 years experience and I'm only 26, I'm still really young. No, my path was, similar to many. I worked in the trades when I was a young man, and my father was a general contractor. So literally I grew up in the trades. And then when there was a little bit of economic slowdown and the trades, came to a screeching halt in the early 80s, my father in his infinite wisdom run me off and said, go to shul. So I ended up signing up for a couple of college courses, and 9 years later, I'm somebody.
Well, that's quite a story. Your career, it's got to require a lot of very wide knowledge, right, of an ever-changing regulatory framework. This is OSHA. So how do you remain an expert as OSHA and safety protocols in general just to continue to evolve?
That is a great way to frame this question here. So there's experts and there's experts. Traditionally, you'll find people that are either generalist that want to comment on everything. They want to get their teeth into it, and then there's some that really steer away from the bulk of things and only specialize in one or two items. And the traditional one or two items that most safety professionals strive to do is like OSHA's top 4 or OSHA's top 10. So the things that are most happening in our world are things like falls. There are many, many falls. That's the number one look at list for OSHA, and unfortunately it causes a lot of serious injuries and fatalities. So there's a handful of people that fine-tune their expertise towards fall prevention, fall protection, the equipment itself, training, and so forth. So they'll just have that tight niche. While others, if they came up in the trades like the construction world with excavations, well, then they're excavation activity guys, and they know all about trenches and road work and backhoes and excavators and that kind of stuff. So, sure. Yeah, it's interesting. That was a great opening question.
Would you consider your knowledge to be kind of more on the broader spectrum or more on the niche spectrum that you were talking about?
I really specialize in a handful of things. I think, given my diverse background, so as a young guy, I grew up in the trade, so I literally can operate anything. I just recently let go my Class A license because I didn't need it, but I've driven just about every piece of equipment. I've operated excavators and water trucks and all that stuff. And then I worked for a separate contractor doing a few high-rise stuff. So I'm, very into the fall protection stuff. And as I became a safety guy, I kind of drug those lessons learned along with me. So I pretty much stick to the main things like excavations, fall protection, confined spaces. And believe it or not, I've been doing a whole lot on slip, trips, and falls. So we probably want to expand a little bit on that low-hanging fruit safety niche right there.
Sure. Is that static, or is that body of law? Is that changing a lot? How difficult is it to stay abreast of what's going on? And you might be working for somebody in a different state, and they might have different regulatory frameworks. How do you stay on top of all of that?
Well, and it's interesting that you pose it that way, because technically there's more than one OSHA.
Sure.
So the OSHA Act rolled out in 1970, and it caught a lot of people off guard, and a lot of state regulators weren't real happy about it. There was a little bit of pushback. So what the federal government made an agreement in the statute that they passed is that states can have their own OSHA plans. They're called state plan states, as long as their rules, this is very important, as long as their rules are as stringent as Fed OSHA, and not to water them down. So, for instance, we happen to have 50 states right now. Half of them are OSHA states, and the other half are state plan states. So I'm based out of California. So we have Cal OSHA. And of course, everybody's rolling their eyes. Man, that's a tough state. It's true. Cal OSHA standards are extremely stringent. They go far and above many Fed OSHA standards. And in fact, there are a lot of Cal OSHA standards that nobody else has.
Okay.
So pretty interesting thing.
So when you are engaged in another state, you have to sometimes back it up. Obviously, you must know the federal statutes because all of them, as you said, start with that. But say you're you're doing some expert work for another state that has different than California, but also higher than the standard. Do you find yourself having to scramble and look up a lot of stuff, or do you just turn down those types of offers? How do you deal with that?
So, first there's, obviously 25 states that are under the federal program. So we do a lot of work out in Texas, which happens to be, under the OSHA, Fed OSHA standards. And
Sure.
Oddly enough, so to become a recognized safety professional, to get some sort of formal credential, all of the exams currently are tested under the Fed OSHA standards. So for you to get one of those credentials, you have to have enough expertise in the federal standards to pass the exam to earn those credentials. So when you look at my card, it has all those little alphabets behind there. Well, that tells you I know at least the basic Fed OSHA stuff. Then, as you mentioned, there's other states, like I do some work in Washington State, and I do some, in fact, quite a bit of work in Oregon. Oregon has its own OSHA, which I tell you, they compete with California. They have a lot of standalone citations, and most of their citations that are built on the OSHA platform, they've added quite a bit. So it's more extensive than you can imagine. So yeah, you really have to keep abreast of the various states or the jurisdictions that you get involved with.
Let's go back to some of your first engagements. Were you looking for expert work, in specific, or did you just kind of receive a call out of the blue one day?
Well, I was pretty fortunate. I was working for a pretty high-end guy in the Bay Area. He had a safety company, and I went to work for him. He's former retired, this, that, and the other things. So he gets a lot of business, and he was one of my mentors, and he helped me become an expert through his company. And then when I left to go to the company I'm at now, I was able to bring those skills and those expertise with me. So I was pretty lucky to be mentored directly into the role as an expert witness.
So you had somebody show you the ropes a bit. What sorts of techniques, what sorts of education did you get from this individual?
The phrase that just resonates with me all the time is trust but verify. So a lot of people have a lot of opinions, and there's a lot of written work out there that sometimes you use for reference. And then even some of the statutes or the regulations, they're not always correct. Some of the opportunities like you find in Cal OSHA, the standards are written with a certain language that says in accordance with, and then they'll quote a standard. So often they're going to quote ANSI or the National Fire Protection Association standards. Well, they don't keep up with that. So when those sunset or lapse, Cal OSHA doesn't go back and change or update their standard. So sometimes I'm involved with a case, and right away I recognize they're quoting a standard that's no longer viable or no longer appropriate. So yeah, you really have to be on your game of trust but verify.
Going back to your earlier engagements, let's talk about prep and maybe how that's evolved some. When you are getting ready to write a new report or give testimony or even do cross, what sorts of techniques did they use and do they use now? So you're experienced enough to know what works and what doesn't work. What are the the
I wouldn't go
preparation
that far, but
what are the preparation methods that attorneys can use with experts that are the most effective for you?
so what I found a successful means for me to get my job done is I both storyboard and I write an outline. Now, the trick is, and this is my little disclaimer, when you're working under an attorney, you have attorney-client work privilege. So your stuff is kind of protected. But under the discovery rules, they can get you for your notes and your raw materials. So sometimes you discover a smoking gun that you just might not share because you don't have the details right, or, it's just a suspicion, or there's just something that doesn't gel. So you're not really putting that information forward. So you have to really be careful what you note down in writing. But I have a big whiteboard and I storyboard just like doing video work. And then I write an outline and I try to do the goals. I have an opening that what I'm trying to show or declare or state. And then the body of it is usually some type of bullet point. And then the summary is I try to tie a knot into it. And then I throw my disclaimer in there that this is based on the information that was presented to me. If new information comes up, I hold the right to, change my opinion if need be. So, that's a basic method.
Is that a collaborative process? Do you take a fairly proactive approach vis-a-vis your attorney? So when you're doing these storyboards and doing your preparation, how much input do you give?
So the attorneys usually keep a firewall between you and the information.
Sure.
They don't want to know a whole lot. They want the highlights. The 30,000 foot view is what one of my main attorneys always tells me, or another one says, just the highlights we go on in 5 minutes, something like that. So it's pretty much the long haul of putting all this stuff together, and very much it's like putting together a puzzle with extra pieces. Sometimes you stumble into stuff that really don't fit or don't match, or a coincidence, or whatnot. So it's putting together a puzzle with extra pieces.
When do you usually get involved in the process? In other words, when the case is just starting out, do you tend to get hired out in the middle of a case towards the end?
That is a open question all the time. I have a half a dozen attorneys that I speak to literally weekly. A lot of times we just, have a conversation about stuff. I have 2 attorneys that we lovingly do beer and burgers. Sometimes we actually get to go out for a beer and a burger. Sometimes it's just that 5-minute call. So we talk about things just to stay in contact. And then I have questions for them, or they have general questions for me. But for the most part, you get involved when the attorney thinks that it's going to go to trial and they want an expert on it right away. The process of giving you the information is pretty detailed for them. A couple of different venues that an expert would serve on. There's criminal, and we all see that on TV. There's civil, which we all hear about. And then there's OSHA. So 3 different venues. They're similar but different. So with the OSHA stuff, that's an administrative court and an administrative process. And in most cases, the judge isn't actually a judge. It's an attorney that's been appointed. So there's all these rules about how you can be a judge and who is a judge and everything. So it's an administrative judge. So it's really like an appointee by the governor or some jurisdiction or something. So with the OSHA stuff, if people make mistakes, I don't believe that judge has the right to put you in jail or, hold you in contempt or anything. I know they could, they can stop you from testifying, or they can, remove your testimony, and they have a lot of controls like that. But it's not the same as a criminal judge or even a civil judge, where if you don't have your ducks in a row, they can make life very, very difficult for you.
That's really interesting. And I assume that the bulk of your work is in front of these OSHA appointees rather than judges. Is that right?
Percentage wise, the higher percentage is with OSHA, because for me, that is my expertise. So I'm a subject matter expert with FedOSHA regulations as well as Cal OSHA regulations. So I don't think that there's a lot of people that really have that subject matter expertise of the Cal OSHA side. So I get a lot of calls because of that. Well, I was there and I learned from the inside, and, kind of the inside joke for me is, everybody wants to be OSHA certified. OSHA doesn't certify anyone unless you're an employee. So I'm one that's OSHA certified. So yeah, it's kind of
actually OSHA certified, Paul.
Yeah. But, again, getting back to kind of the original avenue you were asking on this question. So, there's 3 avenues, and sometimes the preparation is same. So when I'm on an OSHA case, I usually get it after the citation packet has been issued. So until it becomes final from an order from the ALJ, administrative law judge, everything is just allegations. So you have room to push back on Cal OSHA, or, in the federal case, the district manager of the local office. You can do some negotiations, some pushbacks and stuff like that. So sometimes the pursuit is to convince them to either reduce the finding. So there's, in the federal world, there's serious citations and other than serious citations. So, obviously the serious ones are, higher value. So sometimes you can bring up information or evidence that shows that they made the wrong judgment call on the severity. So sometimes it's a work in progress, and that's your goal. The OSHA has an allowance, I guess that's a good word for it, where they can combine or reduce citations. So there's a standard for something that's called lockout tagout. That's the common term, lockout tagout. If they issue, the COSHO issues, say, like 6 lockout tagout citations, you could deal with the OSHA district manager and get that combined down to 2 or maybe 1. So by showing, conditions or, poking holes in their findings, you can get some of these things reduced. Other than that, most of the OSHA ones, I'll just get the case file dumped on me, and it really, I'm flipping through page after page after page, and that's where that trust but verify comes in. And again, this is one of those disclaimers I shouldn't say out loud. We don't always win because the employer is right. We win because the OSHA people have done such a bad job. So OSHA has the burden of proof, and they have to be right. It can't be a near miss. It can't be likely. The burden of proof is 100% on them. So you only have to show that they made enough mistakes. So common mistakes would be like they'll give you a citation for lack of documentation of an inspection. So they're expecting a formal piece of paper that says at the top, inspection form. So you don't have that as a form. So in their findings, they said you didn't document your inspections. When in reality, you send a text message, or you have it on a spreadsheet, or, you send it as an email, or a lot of times on construction site, they'll literally put it on the whiteboard at the job site trailer. So it was documented, and that meets the intent and the spirit of the standard. But the COSHO, the inspector for OSHA, they're looking for a piece of paper that says inspection form. So a lot of times that's what it comes down to. So you have to look at every document and verify, where things are going.
Before you go to a trial, and you have been in a lot of trials, there's a report that you have to write, and that forms the basis of your testimony. When you write your expert report, are you typically given some kind of a skeleton outline, or are you developing reports whole cloth?
Oh, if that was only the case, yeah. Now, pretty much, you write your report in your style. Oddly enough, I was on a case 6 or 7 months ago that the report that I submitted to the attorney, he submits it to another attorney, the opposing side. And that guy complained because the format was exactly like an expert that he uses, and he thought it was odd. So that ended up being my mentor, the gentleman I used to work for. So he taught me this certain style and a certain format, which I've adopted. And, it's my format now, So,
Sure.
What's the odds that something like that would happen? I've looked at a lot of reports and it's all over the board on what style. I do the old school, I do an introduction, then I have a body in bullet points, and then I do a summary closing.
Sure. Well, let's pivot to ethics for a moment, because you were saying, that it's kind of being insinuated that you were being coached, when in actuality it seemed like you were, just following a fairly standard style. Have you ever been pressured to write a report in kind of a specific way, or testify in a way that it's not necessarily something you would agree with? And if so, how do you deal with those sorts of situations?
Well, it's funny that you're bringing up ethics. So, of course, not every attorney is as ethical as you would really want attorneys to be, but at least they're held to a higher standard. There's a
Sure.
whole lot of things that could go bad for an attorney that's not ethical. Sometimes it's a gray area that they live in, and sometimes it's just they cross the line, then bad things happen to them. Safety professionals, I think the only thing that, unless you're really out of the box, I think the only thing you could do is lose credibility. And if you lose credibility, then you lose clients, because it is a small world and everybody talks. So, you must be ethical. I've never been, I should say, obviously, I've never been asked or directed to write in a certain style. Not at all. And I've never been asked or forced or led down the path. This is the way I want your findings to reflect. But lawyers aren't stupid. They first test the waters. So they have you give an unofficial opinion. How do I look? What's my strengths? What my weaknesses? You're just giving them an opinion, and it's usually over the phone, nothing in writing. And often when the people I run with and myself, we don't want a dead dog. Nobody adopts a dead dog. So you get a case and it's so bad, they're in trouble. You have to be honest with them. Hey, this is a bad case. You need to back up a little bit, and you need to figure some kind of settlement, or, you need to figure out some kind of compromise, because things don't look good for you. Often I tell the attorney straight up, here's the other disclaimer. You could be arrogant when you have a lot of work. So my company has enough work where we turn down work that doesn't seem right. The sniff test, like, this one doesn't seem right. We're looking for cases that either we can contribute to and help push the client over the top, or that one that's actually really, really good, that it's easy to push over the top so we don't have to work so hard.
That's a perfect segue. This is normally one of my wrap-up questions, but I'm going to go ahead and ask you now, how important is winning to you? Getting the big W, where this is an actual trial and you win the case. Is that something that comes into the calculus when you are vetting? You're talking about getting the call from the attorney and whether it passes a sniff test. Is it important not only that you can help, but is it important that you're going to be on the winning side of the case?
On a personal standpoint, everybody likes to win. No one likes to lose. The downside of losing is most of the attorneys I work with, I do a lot of work with. So if I lose too many times with them, they might think I'm not the right guy. So there's some downside to losing the case. I've never really lost a case. I've had portions of it not go the way that I've wanted to go. So we had
Right.
an OSHA case that the client had 21 citations. So we were able to upend 18 of them, and the judge upheld, the rest. What's that? 3. Oddly enough, the 3 that she upheld, I thought we were 100% in the clear, and a handful of ones that we beat back, I thought, hey, this is just a shot in the dark. So yeah, it's kind of weird how that goes, but winning is better than losing. But like I said, it's a challenge because the employer isn't always innocent. The problem is the problem is kind of in my favor. The inspectors do such a poor job. You're really going up against the report. And when they do a bad report, then it usually goes well for us. If they do an ironclad report, it's hard for us because, the judge, like in OSHA's case, you're before a regular judge, so somebody that's an attorney. So what's the odds, do you think, that an attorney knows the difference between a mini excavator, a backhoe, and an excavator?
Very little.
Yeah. So when the COSHA cites the wrong standard and they're talking about a different piece of equipment and you point that out to the judge, they don't know the difference. So it's hard to convince them. And yeah, we do photos and videos and everything, but to them, mini X, that's that real tiny thing. It looks just like the big excavator, but size is different. But it's different. There's a different rule, a different standard, a different use. So sometimes it's hard to get the judge to understand, why the COSHA is wrong.
Do you tend to know the experts on the other side of the case?
Very few times.
So once all of this has gone down, do you stay abreast of these cases? Do you find out who wins and loses, or if it settles or anything after the fact?
Big pictures, there's so much going on, you really don't. So, other than, at the water cooler, when you go to the safety conferences with the other safety guys and they tell you, yeah, I lost my shorts, or I beat these guys up. You really don't know what's going on. A lot of times at various safety symposiums meant for safety professionals, people like me, they'll present 1 or 2 cases. I had a really good case, I do a presentation on it and make sure that, I'm not, sharing anything that's proprietary or, embarrassing or something like that. But a lot of these cases make really good presentations at safety conferences so other safety professionals can glean some approach and some successes in their methods.
Sure. Before we wrap up, do you have any last minute advice that you'd like to give to either newer expert witnesses or attorneys that are working with expert witnesses, especially newer ones?
You need to have a script. If you're glib and you think you're just going to roll with questions and see how they work out, no bueno. Just like you hear in the movies, you never ask a question you don't know the answer to. You're not really there as fact-finding when you're in a hearing or a trial. You only ask questions you know the answer to. Sometimes you have to project and guess what answers they're going to give you, but you have to have some knowledge, and then you have to have a follow-up 1 or 2 questions to cover that, because you're trying to get them to say something to benefit you. To be mentored by somebody that's well qualified is great. And then again, we talked about that trust but verify. Extremely important across all avenues. With OSHA, a lot of times they'll write a standard and then the information within that standard has changed and nobody's tracked it. So you can find a lot by rereading that standard and making sure it's the most up to date.
Sage advice. Paul, thank you so much for joining me here today.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite